All rise.
Yes, Mr. Miller.
Well, on behalf of the Miller, I would have remarkably little to say.
Would you like to have the lectern in front of you? Would that help? You,
Just to,
very well.
before.
Yes.
When I intend to elect you, will have needed it fairly soon.
Right.
Lords, a number of formal points in relation to Miller's case. I seem to confirm basically obviously in relation to the competence issue. There was no question of sentence.
Yes.
Although in relation to his sentencing, the facts are little.
Could you just bring us up to date on what happened to him?
Well, he was sentenced to 7 months in relation to a complaint libeling driving whilst disqualified, simplicity, really an observation.
Yeah.
He pled at the first opportunity. The Lancashire report in relation to bill of suspension does not give any hint as to whether or not allowance was made for the early plea. But obviously, the short point is it was a sentence beyond what we would see.
Indeed. Yes. Yes.
The second issue, Norris, relates to the discussion of disqualified driving before the 2007 Act came into effect, and the distinction between indictment proceedings and summary proceedings. In my set of the submission, the principal use of indictment proceedings was simply a progression from repeated summary offending and marked a way for the court to make clear that the case was being taken more seriously, and that was the norm. As opposed, with respect to Lord Rodger Elsferry, association with other matters, and it should also be borne in mind, of course, that in terms of indictment proceedings, Section 103 prosecutions would always, of necessity, stand alone because of the nature of the allegation.
Yes. Yes.
Sorry, how's that work?
Yeah.
Simply because it is an allegation driving whilst disqualified, it is giving notice of previous offending, and as a result was always prosecuted distinctly from, for example, associated with traffic matters.
Yes, it could be put on a separate indictment.
That's right, yes.
But in practice, you're suggesting it be taken summarily, separately, or?
One could have situations, I have experienced some situations where more serious offences are prosecuted on indictment, and there is in secular complaint. But I think the principal point I make is it was used on indictment to mark progression on criminal past into more, or into essentially repeat offending, which
yes.
would mark more seriously.
You could never try it together with dangerous driving?
Not on the same indictment, there would be 2 distinct proceedings.
Yeah, but would they all be heard together by the same?
No,
they wouldn't be.
No, one could have a situation of one jury giving dangerous driving or convicting, and the matter then proceeding before a second jury to establish.
Is that how we do it this side of the border too?
I would imagine so.
I doubt it.
Well, I rather doubt it.
I'm afraid they're not so fair.
I mean, we're very cautious about revealing previous convictions, and I think that's the point, really.
That's when the Road Traffic Act 103 was first envisaged, or its predecessor in Section 99, it may be the same, but certainly in Scotland that would be the approach.
What's the reason for not trying it on the same indictment?
I think because it gives notice of previous.
Oh, I see.
You would only be disqualified if you'd committed an offence.
Yes, that's right.
I mean, the reality was that if you were convicted of the other things, people then pled to this one because they were obviously driving and they couldn't dispute the fact that they were driving while disqualified. So it didn't actually add much to the length of the proceedings, the fact that you had them on technically on a separate indictment, or the charges were separated with everything.
Yes. Lords, those general observations and various statutory provisions are relatively short, because I respect not much of what Mr. Shedd has said, much of which, I think it's fair to say, he adopted from written submissions
Well, if I may say so, you had a very well presented written case, Mr. Brown, and it's been very helpful.
In relation to the principal submissions, I would make two observations. Firstly, in relation to section 29.2 and, of course, in association 3, and the reflection of effects in 3.
Yeah.
In my submission, it's important to remember that what one's dealing with here is a single enumeration system dealing with reservations rather than the amounts of, for example, the kind of powers to legislatures. Accordingly, my respectful submission was the most significant assistance that your lordships can derive is from the Northern-Irish authorities in consideration of the 1920 Government of Ireland Act, and in particular, as has been referred to already, the case of Hume, which in my respectful submission comes closest to the considerations that apply in these appeals. In that regard, in my respectful submission, again, this was touched upon, I simply make reference to the written submissions in relation to the observations about the similarity, synonyms between those two and in respect of the my respectful submission, those submissions did.
Your paragraphs numbers are about number 18, 19 and onwards, is that right? Yeah.
The my respectful submission, therefore, in dealing with legislation under reference to Hume in particular, and the approach taken there, and remembering the use of effect in 29.3, the test of the lordships should be adopting an essentially objective one.
What does that mean?
Well, having regard, obviously, to the intention of the Act as one factor, the affect.
Lloyd.
Sorry?
I'm sorry, you said to the intention of the Act and you added words I did not catch.
The affect.
Affect.
The affect of the Act.
Or
What it affects.
the effect, yes, I'm sorry.
Yes. The effects it has thereafter, and the intendment that one can derive from those effects. Now, in the Canadian cases, obviously, what was, and also to an extent in the Northern Irish cases, what was being considered was a choice between two competing purposes, perhaps. And I accept that there can be different purposes for the same legislation, or even provision of legislation. But in my respectful submission, properly looking at the legislation which one focuses upon here, the 2007 Act, under reference to section 45(7), that in this section, the relevant enactment is an act passed before this Act, it is quite clear that the intention of the Parliament was to have effect on matters reserved, because it is a broad approach to any act passed before the 2007 Act, that was the intended effect. That the effect is clearly that reserved matters are affected, for example, the penalty provisions, and as a result, the intendment of the legislation can be seen to have just that purpose. That being so, in my respectful submission, and following the logic adopted in Hume, this is legislation which should be struck down.
I'm completely lost, Mr. Brown. I mean, the effect was precisely that, presumably that which was intended. I mean, everybody knew what was wanted. You wanted to increase the powers of the sheriff. It didn't have any unintended effect, as far as one knows. Presumably, the sheriff started hearing cases that might otherwise have had to go for trial on indictment.
Yes. This is why I talk about perhaps the distinctions of purpose. The purpose of the 2007 Act generally might be understood having regard, for example, to law and order. But looking to the provision in section 45(7), the only purpose in my submission to be properly understood is the intention to have effect to reserved matters. because it relates to all acts.
Well, it would have been ludicrous to increase the powers of the... Well, I mean, this view could be taken. But it would be bizarre to increase the powers of the magistrate, but then say, oh, but terribly sorry, they can't do it in respect of some offences. Why would they want some either way offences? Why would they want to do that?
Because it is in line with the structure of the constitutional settlement. There are some matters that are reserved to Westminster.
Well, that begs the question, I mean...
Looking at it, the generality of the provision, subsection 7, is very apparent. When you look at the scope, there is no attempt to dissect one type of statute from another, and the attempt is to achieve an overall readjustment of the jurisdiction of the sheriff in summary proceedings.
Yes. Although, in the context of the Scottish provisions on criminal law, looking back to the previous provisions.
Yes. But I think, you see, the reason why I put it this way is because I think the Advocate Deputy is going to say that when you look at the phrase relates to reserved matters, you should, maybe putting words in his mouth wrongly, construe that as relates to reserved matters only.
Yes.
And it doesn't do that because it's so broadly expressed. So it does bring in exactly the point Lord Brown is making, that it's across the board. And that makes one wonder whether we're not really in B at all, and we get into C and then all the qualifications that follow once you start to find your way through this more complicated legislation.
Well, indeed, that's a question of actual interpretation, not a full submission. The interpretation of the constitutional settlement should obviously be approached with particular care.
Oh, yes.
Because of the potential to distort the balance that Parliament intended to have. And it's that distortion of vice versa submission is perhaps, to use loose language, set up potentially by enacting a provision relating to an act before this act.
Yes.
Which can easily reserve matters.
But I think you'd agree, wouldn't you, that the best guide to what the settlement was all about is to be found in the language of the Act.
Well,
so we have to follow through what the Act is telling us.
Well, absolutely, and that's why on the reference to purpose and effect, in vice versa submission, it goes beyond simply the intention. One has to look beyond that. The effect is really to interfere with the reserve matter. And that is really the vice versa submission of the legislation.
Yeah.
I mean, if it had said, in Scotland, the penalty goes up to 2 years imprisonment, I mean, I can see a point. I appreciate under section 1265 references to Scots criminal law include penalties, but this penalty hasn't. I mean, if you actually look at the offence and the penalty for it, it hasn't gone up at all. It's still 12 months, just a question of who can pass it.
Well, I think the Lord's purpose is for summary sentence. The summary sentencing provisions have changed markedly.
Of course they have.
And that is the purpose of the legislation, not simply some broadening of retrieval power. It is sentencing at summary level that has been altered. The fact that it now marries up with the preceding levels of sentence is neither here nor there in my full solution.
No, I mean, previously you wouldn't have been able to get this sentence except after being tried by a jury.
Yes, that's right.
And now you get this. I mean, you were quite a bad boy. I mean, why did you get? This is an offence which, in one sense, it doesn't admit of gradations. I mean, you're either driving while disqualified or you're not.
The gradations will all come in sentencing.
Yeah, I know. The question is, but what is it that causes you to get? Why did you get 7 months? Is it because you're a badly behaved boy from all these other things?
Well, that is one option.
Probation and all that stuff, and thefts and so on.
That is one option. The other option is having greater sentencing powers, sheriffs to be sentenced more heavily.
Well, that's what I'm wondering.
Yes. Now that, as I understand, was not the intention of the report into alteration. It was not to allow heavier sentencing for pre-existing summary matters, but to bring in to a range of disposals matters which previously might not have been before the sheriff.
So this was a plea of guilty, wasn't
Yes.
it? So you can't complain about the mode of trial. It's not as if you would say you wanted the protection of a jury or anything like that. So it's really, your complaint is that by raising the threshold, you affect the mind of the sheriff. And as I think Mr. Shedd was saying that when he looks at the range and he thinks you're looking at your list of previous convictions, you're near the top. You should go somewhere towards the top of the range now available. That is the point, is it?
Well, I mean, somebody could conduct, I don't understand them to have done so, a statistical survey, because, of course, undoubtedly fewer cases will be going on indictment. So, I mean, it's no good simply saying, of course, there are longer terms coming from magistrates, unless you can say, and that outweighs the shorter or the fewer terms of imprisonment for the same offence coming out of the other courts, the superior courts. I mean, we simply don't know whether the overall impact has been to enlarge or reduce the number of people in prison, the periods they do.
I'm sorry, Lawrence, your Lordship is quite right. I don't know what the
I mean, why should we assume the effect is unintended?
Sorry, Lord?
Why should we assume the effect of the legislation is the unintended effect of people being sentenced for longer than otherwise they would have been for the same offence?
Well, without the empirical evidence, one can't really...
Exactly. So why should we assume it?
Well, see that I think both Mr. Shedd and I would have experience from the appeal court in Edinburgh that these are the sort of matters that are now being raised before the court, that sentences are being increased, and that is the subject matter of appeals taken against sentence. That is the only empirical evidence I can...
You say there's a sort of inflation.
There is an inflation.
But it said, I think, against you, well, the protection against that is indeed the appeal court, who are not influenced by what the sentencing, what the method of procedure was below, because they come before them simply as a sentence in relation to the offence that's been committed.
Yes.
So, I mean, the thing is dissipated a little bit by the protection that's available at that level.
The protection exists.
Oh, I mean, it's very difficult to say, because, I mean, you've now got a situation where the legislation says that you get 12 months for an offence which actually is very difficult to commit in any different way. I mean, you just do it. But now you can get 12 months for doing it, whereas previously you could only get 6 on summary.
Absolutely, Lord. I'm sorry, in that sense there's no gradation. The gradation has always been, because the nature of offence is just that, a progressive one, because the number of times one
Yeah, I wonder how many people were people regularly prosecuted on indictment for this offence?
Yes.
Yeah, when they'd done it lots of times.
Prolific offenders.
Yeah.
And then eventually progressed out of the summary procedure into...
And was this gentleman on his way to that situation? It doesn't. He's done it before, I see.
Well, his previous convictions are set out at pages 6, 7 and 8 of the appendix.
He's done it before. So he's certainly done it a few times, so he might have been well on the way, I think.
I have to say, Lord, I think he has done it once before.
Well, no. Was it 143, is it? What section?
No, it's section 103.
103, sorry, 103. 143 is that driving without insurance?
Yes. They tend to run together.
Again, that's a progression, it's not a new one.
Yes.
It starts off without licence, it's banned, and one then drives off disposal.
My point really would be, if the appeal court were confronted with somebody for whom this was the first offence and they found he was sentenced to 8 months imprisonment, they might think quite readily that was rather excessive. And so the gradation point is something that can be perfectly well argued at that level.
I would certainly say, having looked at the record again, having had one previous, under the previous regime, I would have expected this matter to get somebody complaint on 6 months. It would never have been contemplated.
Well, why are you not pleading against sentence then?
And I'm half praying for that.
I mean, are we really going
Are
to
you sure
decide?
it's only one previous? Have you looked at page 7? It's got quite a lot of road traffic.
143.
As well.
Yes, it's in the pen. The 143 is, I see. 103 on page 8. In June's 2007.
Yes. I think that's the only one.
But I mean, are we really going to decide this appeal on the basis of taking a view as to whether this chap would or wouldn't have been tried on indictment previously? It's a bit astonishing approach. No.
Oh, you are, Mr. Brown, because in one sense you are, because you're saying that I thought you were saying a minute ago that, you thought that he would never have got 7 months.
I expressed that.
Yeah, so he would never have been tried and indicted.
No. The fundamental point is not the effect on this particular element, but the fact that there is effect on the summary sentence provision. That is the essence, in my respectful submission, the purpose of Section 45. That is the nub of the appeal.
It may not be its purpose, it may be its effect.
The effect may be, because nobody's done any study of it, that actually there are significantly fewer going on indictment and the overall result is lower, not higher sentences. I mean, we simply don't know.
I wouldn't comment, I could, but I wouldn't.
It won't be lower. I can't see any why it'd be lower.
Well, they could be lower because you could be tried now summarily because he's got up to 12 months and the magistrate might give a lower sentence than had you gone on indictment. I appreciate the maximum is the same now for both, but we just simply don't know what the impact is.
Well, it's the same judge who will be doing the sentencing.
Yes.
It's the sheriff in both cases, so...
But also I recognise this is perhaps a side issue that is not...
I'm not sure it is a side issue, Mr. Brown.
The issue specifically of this element, but the broad picture of my respectful it may be a factor, but the fundamental point I make is the effect of 45(7). That only demonstrates purpose. And the purpose was to use this legislation to reserve matters. That being so, in my respectful submission 29(2) is triggered.
29
2B.
2B, yes. Well, supposing we say no to that, then you go through the exercise.
The only observations, again, in relation to 29(4), which I think at one stage I was expected to speak on, but in fact Mr. Sheriff then came back and covered simply to make reference to the last two case.
Sorry, can I get my bearings? 29(4) we're looking at, yes?
Yes.
And we're looking at your case, are we?
Yes, my case.
Paragraph 62 on.
Yes, that's right. I was reading from paragraph 66. The second limit of section 29(4) envisions a situation in which the law of question applies to both reserve matters and non-reserve, it does not apply to change consistently. Section 29(4) provides a provision which makes modification of the law of question will not be treated as relating to a reserved matter if the purpose of the provision is to achieve consistency in the way the law applies to both reserved and non-reserved matters. There is a clear difference between making modifications of the Scots criminal law in question in order to achieve consistency in the way it applies to devolved matters and making modifications of reserved matters in order to achieve consistency between the reserved matter and the Scots criminal law in question. The provision that makes modifications of reserved matters in order to achieve consistency between the reserved matter and Scots criminal law in question is clearly to be treated as related to reserved matter. And the point I simply make, Lords, is given the context of the Scotland Act, 29(4) is not there to achieve consistency by changing the reserved matter so that it accommodates the Scots law, but rather, in my respectful solution, is that the Scots law can be altered to be consistent. It is a one-way street.
Can I take you back to paragraph 66? Is that addressing our attention to the situation before the Act that's under scrutiny was passed? And is it directing attention to a situation where you have, as I think you're putting it, well, the law in question would be the previous sentencing power of the sheriff, which is the subject matter of the amendment.
Yes.
And you're saying, well, if you look at that, it isn't actually the case that it was applying inconsistently between reserved and non-reserved matters, because again, as we can see, it's across the board. Is that right? The sentencing power was equivalent, whether it was a Scottish statute or a UK statute. And that's really the essential plank, I think, of this part of the argument. Is that right?
So, I mean, it's putting up the ordinary Scot. I mean, it's putting up Scots law jurisdiction. And why is it not trying to keep the two things in line, making them consistent?
Well, as I read 29.4, the point is that there is scope in line, but in one direction only. That's the principal point. One cannot alter the reserved matter to accommodate. In Scots law can be altered to fall into line with the reserved matter.
No,
It relates to.
it's something which modifies Scots criminal law as it applies to reserved matters.
Yes.
Now, is that not what's happening here?
In my respectful submission, the law, no, it is making a reserved matter that apply to the Scots criminal law. In essence, it modifies a reserved matter.
I mean, Scottish criminal law, the penalty as it applies, Scottish penalty as it applies to road traffic is this provision, isn't it?
Yes, which is reserved.
And it's... But, I mean, you're entitled to make... You say it doesn't... you say it's gone out of that because it doesn't... Because you say, I'm just trying to understand
Yes.
the argument, because you've already taken it out under A, is that right? You say it doesn't, I don't actually understand.
I'm not seen the written submissions, but there was an initial proposition that it, which is the issue in 1994,
Yes.
making modification of Scots private law or Scots criminal law as it applies to reserved matters, may have been relating to as opposed to
That's what I wondered. Yes.
that's in the written submission. I haven't pressed that today
Right.
because I think it's difficult.
I see.
Quite so narrow.
Yes.
But in my respectful submission, it is applying to reserved matters. The 1988 Act is the reserved matter.
But what might be said, looking at it the other way, is this, that there is, for policy reasons that we've read about in the papers, a desire to increase the sentencing power of the sheriff in summary proceedings, and that's thought to be beneficial to the Scottish system as a whole. So that's something that's it's a modification that's being made to Scots criminal law, and what is being done in order to achieve consistency in treatment between the application of that to Scottish statutes, which are not reserved, and reserved ones, is to bring them all in together so that you've got consistency right across the board. Now, what is wrong with that as a proposition?
In my respectful submission, the difficulty will be to achieve consistency on modifying the reserved matter.
Well, certainly it does involve evolving that, but it's a question of whether that is for the purpose of achieving consistency between reserved and non-reserved. Otherwise, sorry.
In this case, it is the law that applies to reserved matter,
Yes.
which could be.
I mean, say it had been thought a good idea, instead of extending the penal powers of the sheriffs, to reduce them, and they had knocked it down to 3 months. Exactly the same arguments?
Yes.
Still no good.
Prior to this amendment, Mr. Brown, the 1995 Act didn't apply to the road traffic penalty.
No, reference was made to the statute itself.
It's statute.
Government.
So the question then is, what law? Just going back to your question, what law is it we're talking about here? It makes modification of Scots criminal law as it applies to reserve matters.
Yes. Well, there is an argument, of course, that there's no Scots criminal law that applies to this reserved matter because
Well, it didn't apply to it.
yeah, right.
It didn't, the 1995 Act didn't, as such,
Yes.
govern the jurisdiction of the sheriff
Yes, that's right.
in this matter. Is that right?
And that logic 29.4 doesn't trigger at all.
How do you, where do you go in the Scotland, sorry, in the Criminal Procedure Act? It has a disapplication provision, does it? Can you give the section number
Section 5
of the 1990?
1995 Act is
Yes. Okay.
What does it say again? Can you give
Where
us
have we
it?
got the 1995 there?
Volume 6.
Sorry, which tab again, please?
17.
Which section is it? 5?
It's section 5 on page 2595.
Without prejudice to any other powers conferred by statute, is that
Yes, that's right.
the phrase?
So what?
Section 5.
Yes.
Had 3 months gone up to 6 somewhere? Is that, oh no?
3 months could go up to 6.
Could have, yeah. Yes, of course, that's common.
Sorry, section 5, subsection 1?
Section 2, which is, deals with the sentences for common law, is that right?
Yes, that's right.
There's nothing which deals with statutes, no?
Simply,
I've forgotten this, I should remember.
without prejudice to
That's all it is it?
So you always have to go to the statute, which
Yes.
contain its own code. So then if you go compare that with section 45
Yes.
of the 2007 Act. It does refer to relevant enactment. A relevant offence is an offence under a relevant enactment. Because it's dealing, of course, it's dealing with statutory offences only, and it's dealing with ones which don't fall under section 44. So it's, you say it's innovating on Scots law by introducing a rule now that goes across the entirety of statutory offences. Does that mean that you no longer have to look up the relevant sentencing provisions and
Yes.
you find the code in section 45, do you?
Because it applies to everything.
To everything. 45 applies to all, no, it's 45 applies to all two each-way offences.
Yes.
43 to common law, 44 to summary only,
Yes.
45 to each way.
Yes.
And no doubt the Advocate Deputy will show us, but there'll be a provision in the McInnes report that was suggesting this was helpful to achieve this in the interests of a good order for prosecutions, that it was better to do it on a wholesale basis to make sure they all came in this way. But
Well, again, Lord, this is not constitutional. The 2007 Act is not a constitutional statute. Our statute mentions the words are clear.
yes.
Irrespective of what politicians may say in advance of legislation. Or say in advance of legislation.
where do we find what's happened to Section 5 of the Act, of the 1995 Act? In what, is there anything which, has it been repealed or has it been?
I think it is now called section, what is Section 43?
Yeah, Section 43 deals with Section 40. Section 5
I'm just trying to, yes.
It does amend it, but it doesn't actually take out the words without prejudice to any other or wider powers conferred by statute.
So where does it do that?
Am I right?
Section 43. Which is, you got Section 43?
Yes. Yes, but that's only that's Common Law Offence Act, that's right.
So the words in subsection 2, without prejudice any other or wider powers conferred by statute, can live with section 45, because that is indeed a power conferred by statute.
Yes.
Is that right? I mean, it didn't need to be amended because it's actually
Yes.
achieving it by statute and therefore falls within the formula.
Yes. So does it remain as it was? Seems unlikely. '74.
What?
78.
That's what we're looking at, 78.
So 78 of the.
No, tab 78 you meant.
No, maybe this is just. It is right. I mean, it just remains the same, does it?
78, no, sorry, tab 78 contains the current versions. Section
This is as amended. It's got 12 months there instead.
Yes,
So I see that side. So it just remains as it was, but with the reference now to the statute being to these provisions in there.
yes, that's right.
Thank you.
So actually 5.3 is now repealed. Yeah?
Yes. It doesn't show that on the print, but it must have gone.
Is that?
It's rather odd there.
It is.
Or is it supposed to be italicized? I don't know.
Yeah, good. There's no amendments as far as
Subsection 3 is concerned.
Well,
I think
Section 5 is
if
not.
one looks in at both versions, the original, I think we're still looking at the original.
we are, yes.
If one goes on,
To where is that?
it's on,
Further on in the same tab.
it's a different print style.
Yes.
Where is it?
Oh, yes, just turn on a few pages. But the words that we're talking about in subsection 2 are still there. But subsection 3 has been taken out under reference to footnote 1. And the 12 months is
Oh,
inserted.
yes, sorry, I was looking at the wrong place.
Yes.
Oh, it's 5.2D.
Part through section 40.
5.2D is the 12
Part
months. Yeah.
43B. That's what I was looking at.
Well, thank you very much, Mr. Brown. Where do we go from here? That completes your submission. I don't want to stop you if there's anything more you'd like to say.
I wonder if I might just ask you a very brief question. In section 29, subsection 3, it's one is required to ascertain the purpose of the legislation, and then one's enjoined to have regard to its effect in all the circumstances, among other things.
Yes.
What is in contemplation there, do you think?
My second submission could be a variety of things, including previous documents giving an indication.
I'm sorry?
Previous documents prior to legislation giving its constitutional nature and intention. For example, we have regard to what is contained within Hansard's. I think that's especially been done in this debate. But my submission of that is a principal fact, which cannot be ignored unless there are very strong factors for the other things, is the effect.
Yes, thank you.
Thank you very much indeed. Mr. Devlin. Thank you. Advocate Depute.
My Lords, I invite my lords to answer the questions stated in the Statement of Facts and Issues in the affirmative. And I propose to develop my submissions in two parts. In part one, I would propose to take my lords through the background to section 45 and the relevant legislative history.
Yes.
And then in part two, I would propose to make submissions in relation to the Scotland Act and its application to this particular piece of legislation. But perhaps I could introduce my submissions by making a remark or two on what my lords have heard so far. In my submission, the fallacy at the root of the appellant's submission is the proposition that it is somehow illegitimate for the Scottish Parliament to modify the law on reserved matters.
I don't think the proposition was quite as bold as that.
Well, it wasn't put perhaps that starkly, my lord, but in my submission, in essence, that is that's what the submission comes to. That we have here an amendment to a reserved statute, or a statute subject matter of which is reserved, and the. If the burden of the submission was that there was something surprising or illegitimate about that, then in my submission that would be misconceived. And that's perfectly plain from the terms of paragraphs 2 and 3 of Schedule 4, which tell us in terms that modification of the law on reserved matters is, provided it satisfies certain tests set out in the legislation, perfectly legitimate, and indeed, in my submission, may well be expected in circumstances where the Parliament is effecting legislative reform within its proper province.
But do you accept that ultimately the best guide for us is the wording of the statute? We can't, as it were, take some sort of broad policy view for ourselves about where the boundary would lie.
Oh, indeed, my lord. I accept that one is concerned in relation to the issues around the Scotland Act with a question of interpretation, and that is a question of understanding or making sense of the words used in their proper context. Now, it is my submission that part of the context here, and part of the context in which Parliament has used the words that it has used and enacted the provisions that it has enacted, it is a major piece of constitutional reform. And in my submission, what Parliament has done and can be understood as doing when one analyses the provisions is that Parliament has recognised, first of all, that human affairs don't respect the best efforts of the legislative draftsman.
Just say that again.
Human affairs don't respect the best efforts of the legislative draftsman. And by that, my lord, I mean that however the draftsman may seek to encapsulate particular subject matters in certain forms of words, in practice, particularly when one's dealing with programmes of legislation, things are not that tidy, and it's the second thing that in my submission these provisions recognise is that effective legislation, for the Scottish Parliament effectively to legislate in areas in which it's expected to legislate, it may require to modify the law on reserved matters and to do things which are applied to reserved matters. And of course, the third thing which the statute does is that it seeks to set appropriate boundaries in order to protect the matters which have been articulated as reserved.
Well, I read the statute as recognising that to stop at section 29(2)b would be just too blunt, really. You just can't be as simple as that because of the complications that you refer to. And the draftsman is then trying to make allowance for that in various ways that are spelled out.
Indeed.
That's his attempt to meet the problem that you've referred to of human affairs not respecting precise boundaries.
Indeed, my Lord. Now, I make those remarks simply in order perhaps to set some sort of context for the words that are used by the draftsman, but I accept entirely my Lord's proposition that one is concerned here with a question of interpretation of the statutory provisions.
If that's so, are we going to go straight to them, Mr. Are you going to give us a tour before we get to our destination?
Quite happy to take it that way around, my Lord. What I was going to do was to take my Lord's to section 45 in the background to that, because I suspect that my Lords have clearly got the point, but at certain points in the submissions that have been advanced, there was perhaps a flavour of the notion that what section 45 is about is increasing sentences. And in my submission, that
doing what
was about increasing sentences. And in my submission, that simply was not the policy of this particular section, not the purpose which it was designed to.
Well, I understood Mr. Brown to say that exactly the same argument would apply if, in fact, it had been to reduce the powers of the sheriff, which I should have thought was made it pretty plain.
I think you're going to say that actually it's a rather wider purpose. It's not about levels of sentences so much as the organisation of the court system.
Absolutely, my Lord. In my submission, the purpose of this provision was to enable offences which otherwise would have been prosecuted on indictment to be prosecuted in the summary courts as part of a reform of the administration of justice in Scotland. The purpose was not to increase the sentence in any particular case.
Any more than the converse would have been if it had been decided more of these cases should be heard on indictment with a reduced sentencing power.
Well, indeed, my Lord. And perhaps I could just, again by way of preliminary, and while it's in my mind, make three observations in relation to certain of what Mr. Brown said. It's perhaps worth keeping in mind that the sentencing judge in relation to these matters is the same sentencing judge who would be dealing with the matter if it was tried on indictment. Because, of course, if we're dealing with cases that, if we're dealing with a charge which would previously have been brought on indictment, it would have been brought on indictment in the sheriff court before a sheriff sitting with a jury, and the sentence would have been imposed by the same professional judge as imposes the sentence under the reformed legislation. So that's the first safeguard in relation to the points that Mr. Brown was making. The second is, of course, the appeal court.
There's been no pushing down to the district court of these offences.
The jurisdiction of the district court, as I understand it, remains the same. In fact, the district court is being replaced by a new institution called the JP court. But as I understand it, the sentencing powers, certainly as regards imprisonment, are not changing in relation to that court.
Right, I mean, put shortly, this offence can't be done in the JP court. Or can it?
Well, it certainly couldn't attract the sentence.
No. What's the maximum for JPs now?
60 days, I think. 60 days.
60 days.
Of course, what has also happened under this particular body of reforms is that the 2007 Act has also introduced new forms of alternative disposals. That's alternative to prosecution. and has modified the previous law on alternative disposals so that they are much more uses to be made of alternatives to prosecution, so that cases which would previously have been prosecuted in the summary court are now not prosecuted at all.
I wonder whether it would be helpful if you could do it very briefly, Advocate Deputy, just to give an idea of the background, because a lot of what you're saying really depends on a knowledge of what it was that gave rise to Section 45.
Yes.
Now, there's a lot of material in the bundle, so I'm sure you can do it very briefly, but if you could do it just to give us a feel for where the thinking began and why it was that this section emerged, that would be very helpful.
Yes, indeed, my Lord. The starting point on the particular issue in Section 45 will be the report of the Summary Justice Review Committee under the chairmanship of Sheriff Principal John McInnes. That was a committee, my Lords, which was given a remit to look at the whole structure and system of summary justice in Scotland. And I'll look at the document in a moment. And which made far-reaching proposals for reform of the system of summary justice in Scotland. Now, one of the proposals of that committee, among many, was that the sentencing powers of the sheriff, when sitting in the summary court, should be increased. But should be increased not with a view to increasing the penalty for individual cases, but so that cases which could previously have been tried on indictment and couldn't have been heard in the summary court could now be prosecuted in the summary court.
There is a body of jurisprudence in this jurisdiction, and certainly in Northern Ireland, which enjoins sentences to reflect an increase in the statutory maximum in an adjustment of sentences thereafter. So I understand from what you've just submitted that whether or not there is a similar case law in Scotland, that it certainly wouldn't apply in this context.
Yes. Well, there was no increase in the maximum sentence.
Right. I quite appreciate that.
And that's the key. That's the key point. Perhaps, my Lords, by way of what I would propose to do is take, my Lords, I hope relatively efficiently, to the McInnes report and the subsequent history of this particular provision. It might be helpful to have Section 45 before, my Lords, before I do that.
Well, there are various places to look. I just happen to have the appendix in Martin open at page 171.
Yes, I have the appendix in Miller open at tab 13, and I think it may also be available in another bundle.
Yeah.
Tab 82 in volume 6. And I'm looking first at section 43 on page 49 of the Act, or 49 of the print that I have at tab 13.
Sorry, section what?
Section 43, my Lord.
Yes, sorry.
This is the section that my Lords have just been looking at, which deals with common law offences. Now, of course, a common law offence, in relation to common law offences, there is no statutory maximum penalty when the common law offence is prosecuted on indictment. So there is no increase in the maximum penalty that may be imposed in relation to a common law offence, simply by increasing the powers of the sheriff in summary proceedings. And then section 45 deals with offences which can be prosecuted either way. So offences which could be prosecuted on indictment and therefore which could attract a penalty, if prosecuted by that mode, higher than that which would be available on summary prosecution. And in some cases, we happen to have an offence here where the maximum on indictment was 12 months, but in many cases, statutory offences, trial either way, the maximum penalty on indictment is higher than 12 months.
Is the effect of Section 45(2) to increase sentences in any cases? It obviously doesn't here, but it looks as though it's raising the level generally across all statutory offences.
I've not identified an offence where the maximum penalty on indictment was less than 12 months.
Right.
Now, I wouldn't like to say that there is none such, but I haven't identified one. There are offences where on indictment only a fine is available, but of course that's not affected by this. And as we'll see when we look at the legislative material, it certainly wasn't the policy purpose to increase the sentence in any matter.
Well, I'm not sure whether that fits with subsection 3, which gives powers to the Scottish ministers to amend the specification of a maximum term to bring it up to 12 months. It could be up or down, I suppose, the way it's worded, but it...
Yes. That provides a power for making such a change, but it's not... and perhaps that has to be read along with the provisions of Section 44, which do increase. Section 44 does increase the maximum penalty available for a small number of specific offences. And the thinking behind, and I should say, my lords, that there are many statutory offences which are prosecutable only in the summary court, which are not affected by Section 44, and where the maximum penalty remains at less than 12 months. Section 44 deals with a small number of offences, and my understanding is that they are offences where, under the previous law, they attracted a penalty larger than the maximum otherwise available in the summary court, and it was thought anomalous that they should become offences which attracted a penalty lower than the maximum, having regard to the particular nature of these offences. So those are particular offences, but there is no across-the-board increasing of summary offences.
So it's not the case that all statutory offences now attract 12 months.
It's not, as I understand it, Lord. And of course that's because there are offences. If the policy purpose is to allow cases that could have been prosecuted on indictment to be prosecuted in the summary courts, it would be quite wrong to simply increase the sentences for offences which can be prosecuted only in the summary courts and where the existing maximum is less than 12 months. Now that's been done for a small number of specific offences, but has not been done across the board.
The main offences under Section 44 are assaulting a policeman or an emergency aid worker, aren't they? Something like that.
And my understanding is that it was thought that it would be anomalous